Githurai, and then we're seeing that going all the way through towards that Outer Ring Junction, out towards the Pangani Underpass, and it's bumper to bumper. As you get into Moranga Road, it's moving really slowly. The service lanes will help at some point, but as you get to that tunnel, everybody's stuck, and we're just going to have to go with it right about there. All right, so we're also looking at traffic coming off of Limuru Road, coming in from Village Market, United Nations Avenue, out past the hospital, and then joining Wangari Maathai with that traffic that's going to go through towards Chiromo or then go towards the CBD. Let's look at Cabanas, and then also touching on North Airport Road, going towards the Eastern Bypass. That continues to move. Mombasa is not doing too badly until you get to Capital Centre. It's going to slow down a little bit as you're trying to approach Uhuru Highway, getting through towards Haile Selassie at the junction. Okay, traffic hour proper is where we are right now. Not looking too bad on Langata Road, but keep an eye open for that. Gong Road is also flowing free and fair as you get towards the city mortuary roundabout. An eye on everything. Let's see what happens as we get closer towards the end of traffic hour, and let's talk on Spice FM KE on X.
This is The Situation Room, the home of hard-hitting political commentary and penetrating insights about the state of the nation. This is a talk radio experience like no other. The Situation Room, a place for hard truths, debates, and elevated conversations. The Situation Room, witty, political, engaging, deep, controversial. In the room, we have C.T. Muga, researcher, academic, seasoned political observer, a fountain of wisdom in these politically uncertain times. Ndu Oko, Nigerian by birth, Kenyan by choice, communications expert, Pan-Africanist, a truth seeker and believer in people power, and Eric Latin, agent provocateur, the man in the chair, seasoned journalist, news hound, a man who believes in punching up, not down. This is The Situation Room, the only way to start your day.
Okay, good morning and welcome. Getting into the third hour of Kenya's biggest conversation at a few minutes after 8 o'clock. Our audiences of KTN Home and KTN News, Karibu Sana, as we continue with this conversation this morning. All right, getting into a Justice Thursday's conversation, and coming off of that, our guest is already seated in the studio this morning, and as we look at conversations around land, they're big ones, they are emotive ones, they seem to engulf everybody when we discuss them. And this morning, the mandate of the Land Acquisition Tribunal is what is up for discussion, and Dr. Nabil Orina, who is the chairperson of the Land Acquisition Tribunal, is here with us this morning on this Justice Thursday conversation. Good morning.
Good morning.
How are you?
Fine, thank you.
Karibu Sana to Kenya's biggest conversation.
Thanks for having me.
We're getting into it this morning, and we welcome people with a proverb, and CT does the honors.
The whole of this week, the week of course ending tomorrow, proverbs are from the country of Malawi, formerly Nyasaland, formerly before that former British Central Africa Protectorate, currently Malawi. They have a president.
They do.
Yes, they do. It's actually called Lazarus Chakwera. They even have a vice president. They don't have the burden of a deputy president, it's just a vice president. Saulo Chilema is his name. And then
we see what you did there.
Yeah, we saw. We got it.
But okay, you may carry on.
Well, speaker, let's have a speaker. Now they've mixed it up nicely. It's a lady by the name of Catherine Otani Hare. All right. Oh, they got the independence around the same time we did. Okay. So one could say that we are age mates.
You and Malawi?
Or
Kenya?
No, I'm older than Malawi.
Sorry.
Right. The proverb for the day: ants die in sugar. Ants, A-N-T-S, not auntie, not your father's sister. Ants die in sugar. Simple, straightforward proverb for a Thursday, the day before Friday.
Not bad.
Not bad.
Dr. Orina, does it make some sense to you?
Yeah. Ants die in sugar. Basically, I would say it as that which you like so much sometimes can be your downfall, can lead to your downfall. That's how I would see it.
So beautifully executed. I mean, see, I thought it was a simple proverb. Can you see how it has been simply explained and to the point?
Such a truth, though, man. The thing that you like so much can kill you.
Yeah.
The thing you actually enjoy
Too
so
much
much.
of it.
Too much.
Too much
Yeah,
of it.
Too much of it.
Kill you.
Too much of it can kill you. Okay. You can be incensed with it. It can take over your being. It can make you do things that, you would normally not do naturally. And then you could die. And we've seen that with a lot of land issues in this country, isn't it? And people normally say that the issue of land incenses people to the point whereby sometimes we are bereft of all proper thinking, and it's a really emotive issue, the one thing that you can hold on to. And even as we look at that and those matters, the Land Acquisition Tribunal apparently is a body, and we want to start to figure out, okay, what exactly is that? What is, before we even look at the mandate of it and what you do, what exactly is the Land Acquisition Tribunal?
Okay, thank you for that. I would explain what the Land Acquisition Tribunal is by, first of all, taking a step back and asking what is this acquisition that we're talking about. The acquisition that is in the law is the compulsory acquisition, which then now necessitates the Land Acquisition Tribunal. Under the Constitution, the right to own property is protected and can only be deprived. Someone can only be deprived of his right to own property in accordance with Article 40, Sub-Article 3, if it is compulsorily acquired by government, which means that if the government has a public interest for which it wishes to take some private land to pursue the public interest, then it can compulsorily acquire your property. So the constitutional provision, which is Article 40, Sub-Article 3, states that then if government has to do this, there has to be a law, to enable it to do this, and there has to be recourse for someone who's affected, the property owner, in order to, to go before a court of law and to test whether the acquisition is in compliance with the law. And that is where the Land Acquisition Tribunal comes in. So the Land Act then gives the mandate of listening to grievances arising from compulsory acquisition of private land by government to the Land Acquisition Tribunal. So if a government has an intention to compulsorily acquire your land, say to build a school or to build a road, then you have a right to come before this the Land Acquisition Tribunal to either say that the process of acquiring this land was not proper, or the purpose for which this land was acquired was not a public purpose. Similarly, you can approach the tribunal and say, because the requirement is that if government takes your land compulsorily, and this is a concept that is known as eminent domain, then they have to give you just compensation. They have to compensate you for the land they've taken. So you can also come to the tribunal and say that government expressed an interest in taking my land, but the offer of compensation they have given me is not sufficient. Hence, now the tribunal can resolve the questions that you bring
up.
Yeah.
You've used the term compulsorily quite some.
Yes.
And compulsorily to me appears like something that you have no choice but to do. In what circumstances would government come and take your land, or at least express interest to take your land compulsorily?
The Constitution states that government can only take private land, can only deprive a private owner of their land if there is a public interest or there is a public function for which that land is required. So government cannot take your private land so that it can sell it to someone else. Your private land can only be taken if there is need to expand the road.
Or like build the SGR.
Yeah, to put an SGR station, and government requires that land. So and government has that eminent domain in terms of acquiring land in this regard. So it comes to you and says, this land would be required to expand public facility that is here, and by acquiring it, then we will compensate you to put you as close as possible to the position in which you are. You could probably acquire land somewhere else, or in the alternative, it's also provided in the law that the government can offer you alternative land as compensation if it's acceptable to you. So that then that land is taken and it's used for the public purpose for which it was intended to be used.
So it's the government that determines that the land you own and where it's domiciled is useful to them in the manner that is prescribed by law, isn't it? So I can't tell the government, look, I have land, please come and acquire it compulsorily because I think it would be good for this school. I can't do that.
No, you can't do that. Actually, the process of compulsory acquisition of land begins from an acquiring entity. What is an acquiring entity, which can be either a county government or a national government, writing to the National Land Commission and saying, we wish to compulsorily acquire this particular piece of land because it will be useful for us for, ABC function. And then the National Land Commission has to certify that indeed the purpose for which the national government or the county government wishes to acquire the land is for a public use, and then it initiates the process of now compulsory acquisition. So you cannot approach government to say that I wish to sell or to give my land to you.
Can you refuse if government comes to you and wants to compulsorily acquire your land because it is yours as a private individual? Can you refuse?
You can't refuse if all the, constitutional and legal criteria has been met, and that is that the land is for a particular public purpose, the procedure for acquiring has been followed to the letter, and the compensation that has been given to you is just compensation. And that is why, because it's a rights issue, your right to own property, and that's why there is an avenue for you now to complain, to say, for instance, you have a right to go to court and say this acquisition of land, this compulsory acquisition of land should just be nullified because it was not undertaken properly, because I do not think the purpose for which government wishes to acquire this land is not for public use. But you cannot refuse if the criteria set in the Constitution and the law has been satisfied.
What you're saying, or rather what I hear you to be saying, is that there is a tribunal, right?
Yes.
The tribunal presupposes that somewhere along the line, in this clearly laid out situation you've described, there will be malpractices.
Indeed. The fact that you have an avenue to ventilate an issue you could have is evidence that along the line, the procedure might not be followed to the letter, or someone might, undertake a shortcut in acquiring your property, or probably the intended use of this land is not for public use, or the amount that that the government has proposed to offer you in compensation does not meet the criteria of just compensation. So essentially, that is why the tribunal exists. Not necessarily that there could be foul play, but just to check, just as a mechanism to check that everything is done in accordance with the law, because your right to land should essentially be upheld and respected. So for someone to take away your land, then it must check all the boxes.
Dr. Beyond the extrajudicial killings in this country, road accidents, death by disease, deaths that arise over land issues in this country are significant.
Indeed.
Yes. So there are errors that can be said to be human errors. A mistake was made. Someone did not intend to. But then, who are we to speak? You understand these matters. The matters that one comes across on a daily basis as you go about your daily business. what are the ones which are preeminent? What are the issues that keep coming up over and over and over again with regards to this very thing we're discussing?
Thank you for that. It can also be an issue that when government was coming to acquire this land and trying to identify the ownership of this, the particular land that is being compulsorily acquired, they did not identify the correct ownership. The person was identified as the owner is not, the owner of the property. That is one of the errors that unfortunately also might occur. But then the tribunal's mandate might not extend to determining disputes over ownership. But there could also arise another issue where it's stated in the acquisition that the amount of property, the amount of land that has been acquired is of a particular acreage. But the land that has been acquired is more than the land that the government has stated would be required for the particular purpose. Mm-hmm. It can also be the case that if government comes to you and says, we want to acquire half an acre of your land for expansion of a road, but this is a property that you intended to build a house, in a nice compound, and beautify it. Mm-hmm. So the remaining half acreage of the property is useless, basically. Yes. And you'd come to the tribunal to say, government should have acquired the whole piece of property because whatever has remained is not fit for the purpose for which I intended to use it for. So these are some of the issues that can arise in terms of, the process and, what kind of compensation you acquire from, the property that has been compulsorily acquired.
Mm.
Okay.
Let me ask a different question.
Yes.
What if I want to acquire land from the government? Because government has lots of land.
Yes, there are other mechanisms which are not involved because that is essentially the reverse of compulsory acquisition.
Precisely, but now
yes.
I want to acquire, I want to buy, I want to pay for it, but it's government land.
Well, there are processes of allotment of land, and you would have to apply. And if land wishes to, if government then is okay to allot you some land, and then you pay the required rates and rent for a particular period, because then that you would get at least for a property to do whatever you've asked to do with that property. Let's say, for instance, you want it's a property near the port, and you wish to lease it so that you could have a go down there and store your stuff for a number of years, 5-10 years. The government can lease the property to you with certain conditions, and you have to comply with the conditions. And if you fail to comply with the conditions, then they can take the property back.
Okay.
That is a transaction that can still be done the same way you can do a private transaction with a private landowner.
Mm.
Yeah.
Mm-hmm.
I think my question would be, so I'm hearing about the tribunal for the first time.
Mm-hmm.
And I know a lot of, especially young people. How do we get to you? What's the process like? If I feel the situation was unfairly done, just explain to me how I get to you.
Okay. Indeed, although the tribunal came about through an amendment which was referred to as a Land Value Amendment Act in the year 2019, the tribunal has only been operationalized this year by my appointment. I'm actually the first chair of the tribunal.
Okay.
So previously, before the tribunal was appointed, anybody who was aggrieved still had a right to go before the Environment and Land Court.
Okay.
You would file your claim there, and the Environment and Land Court should issue a decision. Actually, most of the decisions existing that have developed jurisprudence around this come from the Environment and Land Court, which is of the status of a high court. But now, since the tribunal has been operationalized, the first port of call is going to be the tribunal. You cannot go to the Environment and Land Court if you have a grievance from a compulsory acquisition of land. And matters arising out of this, we are going to put out an announcement, I think tomorrow, across newspapers, as well as it will be shared to other stakeholders on how you can file a claim before the Land Acquisition Tribunal. It will be the filing system is the one that the judiciary uses. All claims will be filed virtually, and there will be contacts on someone to assist in case someone has challenges in filing, because now the judiciary has really gone virtual in terms of filings, and so that if anyone has a claim, let's say in any part of the country, you can log into the digital platform of the judiciary, find under the Land Acquisition Tribunal, be able to upload your documents, and it reflects immediately with the secretariat from the Registrar of Tribunals, who are assisting at least to manage the administrative bit of it, and then that claim is transmitted to the respondents, and they put in the responses, and then once it comes to us, then we do the next steps. Most of the hearings are going to be virtual. To ensure that at least there is accessibility, because these tribunals also are part of enhancing access to justice. So that if someone has filed a claim from Mombasa, they do not need to struggle that, the tribunal today is sitting in Kisumu, because there's only one tribunal composed of 3 members. So we're not saying that there's a panel sitting in Kisumu, Kisii, Nyamira, etc. So if someone has filed a claim, you can get a hearing date. You log in virtually. We have a claim from Mombasa, from Kisumu, the same day, and they can all be heard virtually. In limited cases, the tribunal might have to visit certain areas, to ensure that at least there's accessibility, because sometimes the use of technology can enhance accessibility, but in other cases you can limit it, because there are people who do not have access to the proper facilities. So in such instances, then the tribunal can go to where the matters have arisen, and they can have a physical hearing there. Yeah, so that kind of flexibility then ensures that nobody is left out from accessing the tribunal.
Okay, so you mentioned that the tribunal is relatively young, about a year, just under a year. So have you actually started to hear cases?
No, actually, I was appointed 2 weeks ago.
Oh, wow.
Oh, you're like brand spanking new. Okay.
Very.
Yes, I am. So, but now we have put in the proper mechanisms to ensure that at least parties can file, develop the proper standards for filing of the cases, and to ensure that at least we're now ready to go in terms of receiving cases and hearing them expeditiously. I must note also that the law that establishes the tribunal gives the tribunal 60 days to hear and determine matters. And one of the things that we've had a challenge with in this country is the long delay in courts for matters, and for the legislature to have come up with this tribunal is to ensure that there's expeditious hearing and disposal of matters, and because of the nature of land cases, and we already have an environment and land code which has several other land related disputes. As was stated here, that land is very emotive. So by removing this component from the environment and land code and putting it in a tribunal and requiring that the matter be heard within a period of 60 days is to ensure that at least there is a quick dispensation of justice.
Sure, and then also maybe giving rise to the notion that there is quite a lot then in terms of disputes when it comes to individuals and government land, but we can look at that in more detail when we come back from this break. The brand new chairperson of the Land Acquisition Tribunal is Dr. Nabil Orina, and he's here with us on this Justice Thursday conversation to find out, okay, so the government is compulsorily buying land from you. What can you do if you feel that there's something